Hi, I'm Martina Avalos, and I'm a senior lawyer here at the Nieves Law Firm. And today I'd like to talk to you a little bit about the life cycle of a felony case. Essentially, there's three phases of a felony case. The first is the arraignment through the preliminary hearing. And these three phases are kind of like naturally divided by the events that are happening. So arraignment is the first hearing before a judge. It's the first opportunity that somebody has to plead either guilty or not guilty. And it's usually the first chance that that person and their lawyer gets to see what the state is actually charging the person with. And this might be different than what the police had recommended. So it really is a very important court date because in many instances it may be the opportunity to make your first pitch getting out of custody. It may be the time that we set a date to have another motion for release heard. And it's the time that you really get to see what it is that the government is going to be going forward with. So in addition, at that time, we're likely receiving discovery. Now, discovery is just a word for basically the evidence that the government has. We get our own evidence, often having an investigator go out and get videos or talk to witnesses, things like that. But when we say discovery, we often mean what the DA is giving to us. So this first phase, the arraignment through preliminary hearing, and a preliminary hearing is essentially a little mini trial. It's where the state has to put on that evidence, put on the witnesses on the stand in front of a judge, and a judge gets to decide, is there enough evidence to have this person held to answer? Meaning, can the state go forward past preliminary hearing towards trial? And it can be a very big deal because often that phase from arraignment to preliminary hearing, we're negotiating. We're trying to get the case dismissed. And a lot of times that's exactly what's happening. So it really is, you want to kind of build the right foundation. Preliminary hearing happens, and then that would be our intermediary phase, from preliminary hearing to trial. During that time, another document would be filed called an information, and after the information the person's been arraigned on it, again, it's like another opportunity to plead not guilty. Then we go into that second phase where we're really kind of gearing up for trial. We're looking towards what kind of defenses we're going to be putting on. We're going to be thinking about what kind of evidence, whether that's videos or our own witnesses, that we should be turning over to the DA because we're going to be thinking about trial. We're still going to be negotiating. We're still going to be thinking about all of those same kind of issues, obviously trying to get the case dismissed, always. I mean, that's always going to be in the back of our minds. But it's that kind of phase where the pressure's starting to build towards trial. And then there's trial. I mean, that's the thing that everybody knows, right? It's the thing that's in the movies. But trial is really the culmination of all the work in the other two phases. And while I love trial, I love going to trial, it's really a rare thing in many instances because of all the groundwork that needs to be laid in the first two phases. So ideally, as much as we as lawyers might love that phase, and we think it's the most interesting, clearly there's so many movies and TV shows about it, but it's the other two phases where a lot of the work is actually done in terms of getting the case resolved. So hopefully that was helpful, and as always, you can reach out to us if you have any questions.